Okay, so this lecture is looking at product liability. It's relatively a short lecture. So in product liability, we're basically looking at where the product which has been purchased or being used is defective, which obviously you expect otherwise. They shouldn't be defective if you're getting this good or service. So there's obviously a duty of care here from the manufacturers or producers or suppliers. Good examples are Donahue and Stevenson. So this was where the ginger beer was faulty because of the, I think it was snail or slug inside of it, and that made the claimant ill. Another case is Stennis and Hancock. So here some part of the wheel detached, and obviously the wheel must have been defective for that to occur. Another case is Hasseldine. So this is where the lift had been repaired, yet it drops. So clearly it hadn't been repaired properly, it was still faulty. So then we have to look at the breach of this duty. So this is where the product's actually faulty. In Evans and Triplex safety glass, it was basically unclear why the windscreen had shattered. So it could have been down to the maintenance of the thing, it could have been down to the fitting of it because it had been fit a year earlier, and it could have been from the manufacturer. It was unclear, and so there was no clear breach of duty here. Whereas in Grant and Australian Knitting Mills, there was, I think the claimant got a pair of woolen underpants and ended up having incredibly he got dermatitis from it actually, and it was clear here that the fault had to be from the product. There was nothing else where the fault could have arisen. A good case to note is Murphy and Brentwood District Council. This basically talks about the fact that you are only able to claim for your consequential loss as a result of the defective product. You can't claim for pure economic loss. So say if a phone breaks, like it just explodes, nothing happens to you, nothing near you burns, anything like that, you can't actually claim for the phone itself. You can just, so obviously within contract you'd be able to get the money for the phone back, but under tort you can't claim for the item itself, which is the idea of pure economic loss. It's not covered. But the consequential loss, so if it explodes in your hand and you burn yourself, you can claim for that loss. So the Consumer Protection Act of 1987 talks about this product liability being a strict liability, and also various sections talk about various different things, such as section 2.1 talking about who can claim. This is basically anyone that suffers damage due to the defectiveness of the product. In section 5.4 it talks about the fact that claims have to be in excess of £275, and again the fact that you can't claim for the product itself. Section 2.3 talks about who's liable, so this is again the producers, the manufacturers, the suppliers, and section 3 talks about defectiveness. So in section 3.1 it says that safety is not as a person is generally entitled to expect, and then this can be linked back to section 3.3, which is the public expectation test. What would the public expect the safety of this item to be like? Furthermore, we have to, as a claimant, you have to prove that the product is defective. So there are a series of cases. So in Worsley, the claimant suffered toxic shock syndrome, and this wasn't down to the tampons being faulty. It was the fact that the claimant chose not to read the warnings which the manufacturers had provided, and that was why they suffered TSS, not the defectiveness of the product. Similarly, Richardson, it wasn't read that condoms aren't 100% effective. The fact that the condom hadn't been effective that time doesn't mean they were faulty. They're not expected to protect from pregnancy every single time. In Mothercare, a part of the item broke off, it hit him in the eye and blinded him. And the court basically said that the severity of the injury indicates that it had to have been defective. It wasn't a very minor injury. Something went very wrong here. In National Blood Authority, the court held that blood can be seen as a product, and so contaminated blood would be a defective product. In McDonald's Limited, there was a hot safety drink, it burnt the person, and it said that this isn't defectiveness. The safety of a hot drink was as a person is generally entitled to expect. It's a hot drink, it's meant to be hot. There's nothing defective about a hot drink being hot. It was very, I think it's down to common sense, that case, really. And then there's Wilkes. So Wilkes is quite a big case. It was basically a hip replacement, and then there was a fracture. And the claimants were saying, we're entitled to expect this hip replacement not to fracture. Like, they're undergoing surgery, it's a new product, it's going in their body, it's very important. I'm entitled to expect that nothing's going to go wrong. However, it was held that the fracturing of the hip replacement was a risk. The fact that it occurred did not mean it was a defect. Nothing actually went wrong. Whereas in Baker, there was a motorcycle accident, and they couldn't find exactly why it happened, but it was clear that there was corrosion. And looking at it, the only thing that was clear was that there would be no way that the claimant had caused this, and so surely it must have been a design fault. There are also defences to this despite the whole strict liability. So it's mainly, the biggest one is contributory negligence. It's not a complete defence, but it's a slight defence. And then the Act actually provides a lot of the defences. But looking at section 4.1d, one of the defences is that the defect did not exist at the relevant time, so if it existed later on. And another one is section 4.1e, which is the state of the scientific and technical knowledge at the relevant time. That's basically what they knew, so how things develop